The woman standing on my front porch looked like she was ready to declare war over a misplaced garden gnome, and I had a sinking feeling this wasn't going to be a pleasant conversation. "Mr. Oliver, I'm Patricia Henderson from the Riverside Meadows Homeowners Association Board, and we need to discuss your flagrant violation of community standards." She held a tablet like it was a weapon, her manicured finger jabbing at the screen with enough force to crack it. I adjusted myself in my wheelchair, gripping the door frame. "I'm sorry, what violation are you talking about?" Patricia's lips pursed so tight they nearly disappeared. "The ice and snow on the community steps adjacent to your property." Section 4.7 of the HOA bylaws clearly states that homeowners are responsible for maintaining safe passage on all walkways bordering their lots. "Look, Mrs. Henderson, I think there's been some confusion. Those steps don't actually lead to my property. They're part of the community access path to the park area." "Irrelevant." She thrust the tablet toward me, and I could see a photo of some icy concrete steps about 50 feet from my house. "Your lot line extends to include responsibility for this area. You have 48 hours to salt and de-ice those steps, or you'll face a fine of $500. My jaw must have dropped because she continued before I could respond. "Furthermore, if the violation isn't corrected within the specified time frame, additional fines of $100 per day will be assessed until compliance is achieved." "Mrs. Henderson, I don't know if you've noticed, but I'm in a wheelchair." I gestured down at myself, feeling heat rising in my face. "I physically cannot go out there and salt steps, especially not in this weather." Her expression didn't change one bit. "Your physical condition doesn't exempt you from HOA obligations, Mr. Oliver. You knew the rules when you purchased this property. If you're unable to perform the maintenance yourself, you're required to hire someone to do it. The responsibility remains yours regardless of your personal circumstances." I couldn't believe what I was hearing. "Are you seriously telling me that you expect me, a person in a wheelchair, to somehow manage salting steps I can't even access?" "I'm telling you that the HOA expects all residents to maintain their assigned areas according to our bylaws. What you do or don't do personally is your concern, not ours." She tapped something on her tablet. "You've been officially notified. The clock starts now. Have a good day, Mr. Oliver." She turned and walked away before I could formulate a response, her heels clicking on my driveway like gunshots. I sat there in my doorway, the cold February air in Riverside, Connecticut seeping into my house, trying to process what had just happened. After I closed the door, I wheeled myself to my desk and pulled out the thick binder of HOA documents I'd received when I bought the house 18 months ago. I'd read through them before purchasing, but I'd obviously missed something about those steps. I flipped through page after page of dense legal language and property maps until I found the section Patricia had mentioned. Sure enough, there it was. Section 4.7 detailed snow and ice removal responsibilities, and when I cross-referenced the property map, a thin sliver of land that included those steps technically fell under my lot designation. It made no sense from a practical standpoint since the steps were part of a public walking path and didn't provide access to my property, but legally, it appeared I was responsible. I grabbed my phone and called my neighbor, Derek, who lived 3 houses down. He'd been friendly since I moved in, always waving when he saw me out on my accessible front deck. "Hey, Harry, what's up?" His voice was warm and casual. "Derek, weird question. Do you know anything about those steps near my property, the ones that lead down to the park path?" "The community steps. Yeah, what about them? Did you know I'm supposedly responsible for maintaining them, salting them in winter?" There was a pause. "Seriously, That doesn't sound right. Those steps have been there forever. Before you moved in, I never saw anyone from your property maintaining them. I figured the HOA took care of them since they're community access. Well, apparently not. Patricia Henderson just showed up at my door threatening me with fines if I don't salt them within 48 hours. Derek groaned. Oh man, Patricia, she's on a power trip lately. Last month she tried to fine the Johnsons because their holiday decorations stayed up 3 days past the approved removal date. The whole neighborhood thinks she's lost it. Here's the thing though, I literally cannot do this. I'm in a wheelchair, Derek. Those steps are down a slope from my house, and even if I could get to them, I can't carry salt and spread it on icy steps. That's insane. She knows you're in a wheelchair, right? She was looking right at me when I told her. She said my personal circumstances don't exempt me from HOA obligations. Derek was quiet for a moment. Harry, that's discrimination. Like textbook discrimination. You can't require someone with a disability to do something they physically cannot do. That's what I'm thinking. But I don't know what my next move should be. Document everything. Save any emails or letters they send, and maybe reach out to a lawyer. This feels like it could get ugly. We talked for a few more minutes before I thanked him and hung up. I sat in my living room, looking out at the gray February afternoon, feeling that familiar frustration that came with being treated like my disability was an inconvenience to other people rather than something they needed to accommodate. I'd been in a wheelchair for 6 years, ever since a car accident on I-95 left me with a spinal cord injury. I'd spent those years learning to navigate a world that often seemed designed to exclude me, fighting for accessibility and reasonable accommodations in housing, employment, and daily life. I'd moved to Riverside specifically because this house had been advertised as wheelchair accessible, and the community seemed quiet and peaceful. The irony wasn't lost on me that the HOA was now demanding I perform a task that required walking, climbing steps, and carrying heavy bags of salt. That evening, I drafted a formal response to the HOA. I kept it professional and factual, explaining that as a wheelchair user, I was physically unable to salt the steps in question. I referenced the Americans with Disabilities Act and Fair Housing Act, noting that I was requesting a reasonable accommodation in the form of either reassigning the responsibility to the HOA itself or to a different property owner. I sent the email to the general HOA contact address and copied Patricia Henderson directly. The next morning, I received a terse response from Patricia. Mr. Oliver, your request for accommodation has been reviewed and denied. The HOA board maintains that property maintenance obligations supersede individual circumstances. You remain responsible for complying with Section 4.7 within the specified time frame. Failure to comply will result in fines, as previously stated. The HOA does not provide individual maintenance services to residents regardless of their personal situations. I read the email 3 times, each time getting angrier. The casual dismissal of federal disability rights laws was breathtaking in its arrogance. I immediately started researching disability rights attorneys in Connecticut. By noon, I'd contacted 3 law offices. The first 2 said they'd get back to me after reviewing my case. The third, a lawyer named Michael Chen at a firm in Hartford, asked me to come in that afternoon. Michael's office was in a modern building with excellent accessibility features. He met me in the lobby himself, a man in his 40s with sharp eyes and a firm handshake. Mr. Oliver, thank you for coming in. I've dealt with HOA discrimination cases before, and from what you described on the phone, this sounds pretty clear-cut. In his office, I walked him through everything. Patricia's visit, the the HOA bylaws, my disability, and the email exchange. He took notes and asked specific questions about timing and exact wording. "Here's the situation," Michael said, leaning back in his chair. "The Fair Housing Act requires HOAs to provide reasonable accommodations for residents with disabilities. What they're demanding of you is not just unreasonable, it's impossible given your physical limitations. Their refusal to accommodate you is textbook discrimination. So, what do I do? We file a formal complaint with the Department of Housing and Urban Development. We also send the HOA a strongly worded letter making it crystal clear that they're violating federal law. Often, that's enough to make them back down. If they don't, we can pursue legal action." "How long does this typically take?" "The HUD complaint process can take several months. But the letter to the HOA should get a response within days. The threat of federal investigation tends to focus minds pretty quickly." I hired Michael on the spot. He said he'd have the letter drafted and sent by the next morning, which would still be within the 48-hour time frame Patricia had given me. That night, I barely slept. I kept running through scenarios in my head, wondering if I should have just paid someone to salt the steps and avoided the conflict. But every time that thought came up, anger pushed it away. This was wrong. Fundamentally, legally wrong. And if I let it slide, what would Patricia and the HOA board demand next? The following afternoon, Derek texted me. "Dude, did you see the community Facebook group?" I didn't use Facebook much, but I logged in and navigated to the Riverside Meadows homeowners page. The newest post was from Patricia Henderson, and it made my blood boil. "Reminder to all residents. HOA bylaws apply equally to everyone without exception. Recent attempts by certain residents to claim special treatment will not be tolerated. We are a community of rules and standards. If you cannot or will not comply with basic maintenance requirements, perhaps this is not the right community for you." The post had dozens of comments, most of them supportive of Patricia, with residents chiming in about the importance of maintaining standards and not making excuses. But a few people pushed back. Derek had commented, "Pretty sure denying reasonable accommodations to people with disabilities is illegal, Patricia." Someone named Susan Miller wrote, "This is really low, even for you. We all know who you're targeting with this post." But Patricia's supporters drowned them out. One woman named Jennifer wrote, "If people don't want to follow the rules, they should move somewhere without an HOA. Simple as that." I felt sick reading it. Patricia was essentially putting a target on my back, making me a community pariah for daring to assert my rights. Michael's letter went out the next morning via email and certified mail. He'd copied me on the email, and I read it with satisfaction. It was 5 pages of detailed legal analysis, citing specific provisions of the Fair Housing Act and ADA regulations. It outlined the HOA's obligations to provide reasonable accommodations and warned that continued discrimination could result in federal complaints, civil litigation, and significant financial penalties. The letter concluded with a demand that the HOA immediately withdraw the fine threat, remove the maintenance requirement from my property, and provide written confirmation that no discriminatory action would be taken against me. 2 hours after the email was sent, my phone rang. It was an unknown number with a Connecticut area code. "Mr. Oliver, this is Lawrence Martin. I'm the president of the Riverside Meadows HOA board." His voice was tight and controlled, like he was choosing each word carefully. "I received a letter from your attorney this morning. I think there may have been some miscommunication with Patricia Henderson." "Really?" "Because her email seemed pretty clear to me." I want to assure you that the HOA board takes disability rights very seriously. We never intended to discriminate against you. However, we also have obligations to maintain community standards and safety. Mr. Martin, I understand that, but you're asking me to do something I literally cannot do. That's not about community standards, that's about basic physical ability. I hear you. What if we arranged for the HOA to handle the salting of those steps this winter, and then we revisit the property line designations in the spring? Perhaps we can find a solution that works for everyone. It sounded reasonable on the surface, but something in his tone made me cautious. I'd be willing to discuss that, but I need to see it in writing and I need confirmation that no fines will be assessed. Of course. I'll have our attorney draft something today. And Mr. Oliver, I hope we can resolve this amicably without involving federal agencies or further legal action. There it was. He was worried about the HUD complaint and potential publicity. Mr. Martin, I'm happy to resolve this amicably as long as my rights are respected and I'm not being discriminated against. Understood. You'll have something in writing by end of business today. He hung up, and I immediately called Michael to update him. Don't trust anything until you see it in writing, Michael said. And even then, have me review it before you agree to anything. HOAs sometimes try to get people to waive their rights as part of settlement agreements. That's what I figured. He sounded nervous about the HUD complaint. Good. He should be. Keep me posted on whatever they send over. That evening, I received an email from Lawrence Martin with a PDF attachment. The document stated that the HOA would assume responsibility for maintaining the steps in question for the remainder of the winter season, that no fines would be assessed against me, and that the board would review property maintenance assignments in the spring to ensure equitable distribution of responsibilities. It also included a clause stating that I agreed not to pursue any legal action or administrative complaints related to this matter. I forwarded it to Michael immediately. He called me 20 minutes later. Don't sign this. That waiver clause is exactly what I was worried about. They're trying to get you to give up your right to hold them accountable. So, what do I counter with? I'll draft a revised version. They can agree to handle the steps and not fine you, but you're not waiving your right to file complaints about discrimination. That's non-negotiable. Michael sent the revised version to Lawrence Martin the next morning. For 2 days, I heard nothing. Then, on Friday afternoon, Patricia Henderson showed up at my door again. This time, she looked even more furious than before. Her face was red, and she was clutching papers so hard they were crumpled. You've made a serious mistake, Mr. Oliver. Her voice shook with barely controlled rage. You think you can hide behind disability laws and bully this HOA? We have rights too. We have a responsibility to maintain property values and community standards, and we will not be intimidated by frivolous legal threats. Mrs. Henderson, I'm not bullying anyone. I'm asking for a reasonable accommodation that I'm entitled to under federal law. You're entitled to nothing special. You bought property in this community knowing the rules. If you can't handle the responsibilities, you should sell and move somewhere more suitable for your condition. My hands gripped my wheelchair armrests. Are you seriously telling me to move because I'm disabled? I'm telling you that we're not going to give you special treatment. The HOA board met yesterday, and we voted to reject your attorney's proposed agreement. The original fine stands. You have until Monday to salt those steps or face penalties. Mrs. Henderson, you do realize that what you're doing is illegal, right? What's illegal is trying to extort an HOA with false discrimination claims. I've consulted with our attorney, and he's advised us that we're on solid legal ground. Your disability doesn't give you the right to ignore community obligations." She shoved the crumpled papers at me. They were copies of the original violation notice with a stamp at the bottom. Final notice fines will be assessed Monday, February 17, 2025. "This is your last warning, Mr. Oliver. Comply or face the consequences." She left, and I immediately called Michael. "They're doubling down," I told him, my voice shaking with anger and frustration. "Patricia just delivered a final notice. They're going to fine me starting Monday." "Perfect." Michael's voice was calm, but I could hear the steel underneath. "That's exactly what we need. Let them assess the fine. Don't pay it. We'll file the HUD complaint today and add the fine as evidence of ongoing discrimination. They're hanging themselves. Are you sure?" $500 is a lot of money to let them take. They're not going to take it. By the time this is done, they'll be begging you to let them rescind every penny. Trust me, Harry, I've seen this play out before. HOAs think they're untouchable until they realize federal law doesn't care about their bylaws. That afternoon, Michael filed the formal complaint with HUD's Office of Fair Housing and Equal Opportunity. The complaint detailed everything: the initial demand, my disability, my request for accommodation, the HOA's refusal, Patricia's hostile communications, and the threatened fines. The weekend was torture. I kept checking my email obsessively, half expecting another message from Patricia or Lawrence Martin. I barely ate, my stomach churning with anxiety about what Monday would bring. Derek stopped by Sunday afternoon with groceries, which was incredibly kind of him. We sat in my kitchen, and he updated me on the neighborhood gossip. "People are starting to talk," he said. "Not everyone agrees with Patricia. A lot of us think she's gone too far this time. It doesn't feel like it, looking at that Facebook post. The people who disagree with her are quieter, but we're here. Nobody wants to get on Patricia's bad side because she's vindictive, but this situation is different. You're clearly being discriminated against, and it's making people uncomfortable." I appreciate that. I really do. I just wish someone on the HOA board would stand up to her. Lawrence is pretty much her puppet. She's been on the board for 8 years, and she runs everything. The other board members are mostly retirees who just go along with whatever she says. Monday morning arrived. I forced myself to eat breakfast and tried to focus on work. I did IT consulting from home, which gave me flexibility and independence. But that day, I couldn't concentrate. Every email notification made my heart race. At 10:30, I received an email from the Riverside Meadows HOA billing department. It was an invoice for $500, labeled Emergency Fine Safety Violation Property Maintenance Failure. The due date was listed as March 3, 2025. I forwarded it to Michael immediately. "Got it," he replied. "This is good evidence. Don't respond to them. Let me handle all communication from here." The rest of Monday was quiet, but Tuesday morning brought a new development. I received a certified letter from a law firm representing the HOA. The letter stated that I was in violation of the community covenants, and that if I didn't pay the fine within 30 days, they would pursue legal action to collect the debt and potentially place a lien on my property. I was reading the letter when my phone rang. It was Michael. "Harry, I just got an interesting call. HUD is already reaching out to the HOA about the complaint. That was fast, which suggests they see this as a pretty clear-cut case." "What does that mean for me?" "It means the pressure is on them now. HUD will investigate, request documentation, and interview both parties. The process usually takes months, but the fact that they're already contacting the HOA shows they're taking it seriously. I just got a letter from the HOA's attorney threatening to put a lien on my house." "Send it to me right now." I'll respond to their attorney directly. They're trying to intimidate you, but it's not going to work. Over the next week, things escalated in ways I couldn't have predicted. Someone in the neighborhood leaked the story to a local news reporter, and suddenly, I was getting calls from Connecticut news stations wanting to interview me about disability discrimination in HOAs. Michael advised me to talk to them. Public pressure can be helpful in these cases. HOAs hate negative publicity because it affects property values. I agreed to one interview with a reporter named Sarah Chen from WFSB Channel 3 in Hartford. She came to my house with a cameraman, and I told her the whole story. She asked pointed questions about the HOA's demands and my attempts to get accommodation. "What would you say to Patricia Henderson if she was here right now?" Sarah asked. I thought about it carefully. "I'd say that disability rights are human rights. I'm not asking for special treatment. I'm asking to not be penalized for something I physically cannot do. That's not unreasonable. That's basic human decency." The story aired on the evening news 2 days later. They'd also interviewed Lawrence Martin, who looked extremely uncomfortable on camera as he insisted the HOA doesn't discriminate and was working to resolve the situation amicably. They tried to get Patricia on camera, but she'd refused to comment. The reaction was immediate. The story was picked up by other local news outlets, and then by a disability rights blog that had a national following. My phone didn't stop buzzing with messages of support from strangers, but it also made things in the neighborhood worse. Some residents rallied around me, but Patricia's supporters became more vocal. Someone put a note on my door that said, "Stop making us look bad. Pay your fine and shut up." Derek helped me file a police report about the threatening note, though the Riverside police said there wasn't much they could do without evidence of who left it. The following Monday, 3 weeks after Patricia's initial visit, I received a letter from HUD. They were formally investigating the complaint and had requested extensive documentation from the HOA, including all bylaws, property maps, board meeting minutes, and correspondence with me. They were also requesting an interview with me. The HUD investigator, a woman named Angela Thompson, called me that afternoon to schedule the interview. She was professional and thorough, explaining the investigation process and what I could expect. "Mr. Oliver, I want you to know that we take fair housing violations very seriously. Based on the initial documentation you provided, there appears to be merit to your complaint. However, we need to complete a full investigation before making any determinations." "I understand. How long does this usually take?" "It varies, but given the straightforward nature of your case, I'd estimate 3 to 4 months for the investigation and initial determination." "And what happens if you determine they discriminated against me?" "If we find reasonable cause to believe discrimination occurred, we'll first attempt to facilitate a conciliation agreement between you and the HOA. If that's unsuccessful, the case can proceed to federal court." The interview itself happened 2 days later over a video call. Angela spent over 2 hours asking detailed questions about everything that had happened. She was particularly interested in Patricia's statements about my disability and the HOA board's rejection of accommodations. "Did Mrs. Henderson specifically reference your wheelchair or disability when she told you to comply with the maintenance requirement?" Angela asked. "She said my physical condition and personal circumstances didn't exempt me from HOA obligations." She was looking right at me in my wheelchair when she said it. "And did any HOA representative ever suggest an alternative solution, like having the HOA handle the maintenance or transferring the responsibility to a different property?" Lawrence Martin mentioned something like that initially, but then they pulled back and insisted I had to comply or face fines. Angela took extensive notes. Near the end of the interview, she said something that gave me hope. "Mr. Oliver, based on what you've told me and the documentation I've reviewed, it appears the HOA failed to engage in an interactive process to determine reasonable accommodations. That's a significant problem for them. I'll be interviewing HOA board members next week. I'll be in touch." A week later, the neighborhood Facebook group exploded. Someone posted that the HOA board had held an emergency meeting about the HUD investigation. Patricia had apparently argued that the board should fight the complaint vigorously, while Lawrence Martin and some other board members were worried about the legal and financial risks. According to the Post, one board member had resigned in protest, saying they wanted no part of discriminating against a disabled resident. Derek confirmed the gossip when he called me. "It's tearing the board apart. Patricia is furious and blaming everyone but herself. Lawrence is trying to do damage control, but it's a mess." 3 days later, I received an email from Lawrence Martin requesting a meeting. He wanted to discuss a settlement. Michael advised me to meet with him, but to have my attorney present. "Don't agree to anything without running it by me first, but let's hear what they have to say." The meeting was held at the community clubhouse, which thankfully was wheelchair accessible. Lawrence Martin was there with the HOA's attorney, a middle-aged man named Richard Caldwell. Patricia Henderson was notably absent. "Thank you for coming, Mr. Oliver," Lawrence began. "We wanted to discuss resolving this matter without further conflict." "I'm listening," I said. Richard Caldwell opened a folder. "The HOA board has reconsidered its position regarding the maintenance requirement for the steps in question. We're prepared to offer the following resolution. The HOA will permanently assume responsibility for maintaining those steps. The $500 fine will be rescinded and removed from your account, and the HOA will pay $5,000 to cover your legal fees and any inconvenience this matter has caused." Michael leaned forward. "And what about the HUD complaint?" "We'd ask that Mr. Oliver withdraw the complaint as part of the settlement." "Not happening," Michael said flatly. "My client has the right to pursue his complaint regardless of any settlement. The HUD investigation serves a broader purpose beyond just resolving this specific situation." Lawrence shifted uncomfortably. "But surely if we've resolved the underlying issue, there's no need for further federal involvement." "The underlying issue is discrimination," I said, finding my voice. "This isn't just about the steps or the fine. It's about how your HOA treats people with disabilities. What's to stop Patricia from finding some other way to target me or another disabled resident?" "Mrs. Henderson's conduct is being reviewed by the board," Lawrence said carefully. "We take your concerns seriously." "Then you won't object to the HUD investigation continuing," Michael said. "Now, let's discuss the actual terms of a settlement. $5,000 doesn't begin to cover the emotional distress, harassment, and discrimination my client has endured. We're looking at $50,000, a written apology from the HOA board acknowledging the discrimination, mandatory disability awareness training for all board members, and a review and revision of all HOA policies to ensure ADA compliance." Richard Caldwell's eyes widened. "That's completely unreasonable. What's unreasonable is demanding a wheelchair user salt steps. What's unreasonable is telling a disabled person to move if they can't comply with physically impossible requirements. What's unreasonable is posting about them on social media and creating a hostile living environment. $50,000 is more than reasonable given the facts of this case." The meeting ended without agreement. Lawrence said they'd take the demands back to the board and respond within a week. As Michael and I left, he said quietly, "They'll come back with a counter-offer. They're scared. The HUD investigation has teeth and they know it." He was right. 3 days later, Richard Caldwell emailed a revised settlement proposal. $30,000, the fine rescinded permanent transfer of step maintenance responsibility, a written acknowledgement that mistakes were made in handling Mr. Oliver's accommodation request, and mandatory training for board members on fair housing laws. Michael and I discussed it over the phone. "It's not perfect, but it's substantial," he said. "The acknowledgement is weak, but combined with the money and policy changes, it's meaningful. The question is whether you want to accept it or hold out for more." I thought about it for a long time. Part of me wanted to push harder to make sure Patricia Henderson personally faced consequences for what she'd done. But another part of me was exhausted from the constant stress and conflict. "I want one more thing," I told Michael. "I want Patricia Henderson removed from the HOA board. I can't live in this community knowing she has power over me." Michael conveyed the demand. 2 days later, Richard Caldwell called him directly. "The board has agreed to request Mrs. Henderson's resignation. If she refuses, they'll hold a vote to remove her. They're also willing to increase the settlement to $35,000 if Mr. Oliver agrees to confidentiality regarding the settlement terms." "No confidentiality clause," I said immediately. "What happened to me should be public so other people know their rights." After another round of negotiation, we reached a final agreement. $35,000, no confidentiality clause, Patricia's removal from the board, permanent transfer of step maintenance, a formal written apology from the board acknowledging they failed to provide reasonable accommodations and engaged in disability discrimination, and comprehensive fair housing training for all current and future board members. I also insisted that the HUD complaint continue. Michael explained to the HOA's attorney that this was non-negotiable. The investigation would either find in my favor or it wouldn't, but I wasn't going to withdraw it as part of the settlement. The settlement agreement was finalized in early April. I received the check and the formal apology letter on the same day. The apology was actually better than I'd expected. It didn't try to minimize what had happened or make excuses. It acknowledged that I'd been discriminated against because of my disability, and that the HOA had failed in its legal and moral obligations to provide reasonable accommodations. Patricia Henderson resigned from the HOA board the following week. According to Derek, she'd been furious and had sent a scathing email to the entire board calling them cowards. But she was gone, which was what mattered. The HUD investigation continued through the spring. In June, I received the determination letter. HUD found reasonable cause to believe that the Riverside Meadows HOA had violated the Fair Housing Act by failing to provide reasonable accommodations to me as a person with a disability. The finding detailed numerous failures. The initial refusal to consider alternatives, the dismissive treatment of my disability, the hostile communications, and the failure to engage in an interactive process to find solutions. HUD also noted that the HOA had subsequently taken corrective action through the settlement agreement and new training requirements. They ordered the HOA to implement additional measures, including creating a formal accommodation request process and designating a board member responsible for ensuring fair housing compliance. The determination was technically confidential, but I had the right to share it. I sent copies to the local reporters who'd covered the story, and several ran follow-up articles about the outcome. By summer, life in Riverside Meadows had settled into a new normal. A special election was held to fill Patricia's vacant board seat, and a younger resident named Tom, who'd been vocal about supporting disability rights, won easily. The new board made it clear they wanted to turn the page and create a more inclusive community. Derek and several other neighbors organized a community barbecue in July at the clubhouse. To my surprise, Lawrence Martin approached me there and apologized personally. "Harry, I want you to know that I deeply regret how we handled your situation. I should have stood up to Patricia from the beginning. I let her push me around because it was easier than confronting her, and you paid the price for my cowardice. I'm truly sorry. It wasn't a script or a legal document. It was a real apology from a person who'd recognized his failure." I accepted it. "Thank you, Lawrence. That means something." The HUD determination had consequences beyond my individual case. Several residents who'd been quietly dealing with their own HOA issues, including an elderly woman who'd been denied permission to install a wheelchair ramp, came forward and got the accommodations they needed. The board, terrified of another federal investigation, bent over backwards to comply with requests. In August, I received a letter from a disability rights organization in Boston. They wanted to feature my case in their newsletter as an example of successful self-advocacy. They also asked if I'd be willing to speak at a conference about fighting HOA discrimination. I agreed. In September, I traveled to Boston and told my story to an audience of disability advocates, attorneys, and people with disabilities who were facing similar battles. The response was overwhelming. People came up to me afterwards sharing their own HOA horror stories and thanking me for fighting back. One woman, who was deaf and had been fighting her HOA over visual alert systems, asked me, "How did you stay strong when everyone was against you?" "Not everyone was against me," I told her. "I had good neighbors, an excellent attorney, and federal law on my side, and I stayed angry enough that giving up felt worse than fighting." She smiled. I needed to hear that. Back in Riverside, the community genuinely started to change. The new board approved accessible upgrades to common areas, including adding curb cuts to several sidewalks and installing automatic door openers at the clubhouse. They revised the bylaws to explicitly include reasonable accommodation procedures and added language about non-discrimination. Tom, the new board member, reached out to me in October. "Harry, we're working on updating all our community policies. Would you be willing to review them from an accessibility perspective? We want to make sure we're not missing anything." I agreed and spent several weeks reviewing documents and providing feedback. It felt good to be consulted rather than confronted. In November, Derek invited me to join a neighborhood poker night that met monthly. I'd been hesitant about socializing, worried that people would be weird around me after everything that had happened. But the guys at poker night were welcoming and treated me like anyone else. We played cards, talked trash, and became friends. One night in December, as I was leaving Derek's house after poker night, I ran into Lawrence Martin on the sidewalk. We hadn't really spoken since the barbecue. "Harry, how are things going?" he asked. "Good, actually. Really good. I'm glad. The neighborhood is better with you in it." "I hope you know that. I'm starting to." The anniversary of Patricia's first visit rolled around in February 2026. I realized I'd been thinking about it less and less. The trauma had faded to memory. The anger had cooled to a reminder of something I'd overcome. The steps that had started everything were properly maintained now by the HOA's contracted landscaping service. I'd wheeled past them countless times, and they were just steps, nothing more. In March, Michael called me with interesting news. "Harry, I just got contacted by another HOA resident in Connecticut. She's facing discrimination over her service dog. She found out about your case and wants to know if I can help her. I'm going to take her case, and I wanted you to know that what you did is having ripple effects. You made it easier for other people to stand up for themselves. That might have been the best outcome of everything. Not the settlement money, not Patricia's removal, not even the policy changes. It was knowing that my fight had made it easier for someone else to fight theirs. I continued speaking at disability rights events, sharing my story and encouraging others to know their rights and use them. I talked about the fear of confrontation, the exhaustion of having to educate people about disability law, and the ultimate satisfaction of winning. In May 2026, I received an unexpected email. It was from someone named Margaret who identified herself as Patricia Henderson's sister. She wanted to meet with me. I was immediately suspicious and called Michael. Should I talk to her? That's up to you. You have no obligation to, but there's no legal risk in hearing what she has to say. If you want, we can meet in my office. We arranged the meeting for the following week. Margaret turned out to be a woman in her 50s with a kind face and tired eyes. She was nothing like Patricia. Mr. Oliver, thank you for agreeing to see me. I want to apologize for my sister's behavior. What she did to you was wrong, and I've told her that repeatedly. I appreciate that, but you're not responsible for her actions. I know, but I wanted you to understand something about Patricia. She's not an evil person, despite how it might seem. She spent her entire life trying to control everything around her because she's terrified of chaos. Our mother was an alcoholic. Our father left when we were kids, and Patricia basically raised me. She learned that if she controlled every detail, if she enforced every rule rigidly, she could create order out of chaos. That doesn't excuse discrimination, I said quietly. No, it doesn't. It explains it, but it doesn't excuse it. Patricia sees any deviation from rules as a threat. When you asked for an accommodation, she didn't see a person with a disability seeking help. She saw someone trying to break the rules she'd worked so hard to establish. It was wrong, and she's paying the price for it. What do you mean? Margaret looked down at her hands. Patricia lost her job. She worked in property management, and when her employer found out about the HOA determination, they let her go. Her marriage is struggling. She's depressed and isolated. I'm not asking you to feel sorry for her, but I wanted you to know that there have been consequences. I didn't know what to say. Part of me felt vindicated that Patricia had faced real repercussions, but another part felt sad that someone's life had fallen apart, even someone who'd treated me terribly. I hope she learns from this, I finally said. I hope she gets help and becomes a better person. I hope so too. Thank you for listening, Mr. Oliver. After Margaret left, Michael and I sat in his office quietly. That was heavy, he said. Yeah, I don't know how to feel about it. You're allowed to have complicated feelings. You were the victim of discrimination, and you had every right to fight back. Patricia's consequences are the result of her own choices. That's not on you. I know. It's just strange to think about how much everyone's lives have changed because of those stupid steps. Life continued to improve through 2026. I'd made genuine friends in the neighborhood. My consulting business was thriving, and I was doing meaningful advocacy work. The HOA functioned smoothly with reasonable people in charge. In August, the community held its annual summer festival. I'd skipped it the previous year, still too raw from everything that had happened. But this year, I went. The festival was held at the community park, and there was live music, food trucks, and games for kids. Derek and I hung out by the beer garden, watching people enjoy themselves. Tom from the HOA board came over. Harry, I wanted to tell you something. We're naming the accessible playground we're building the Harry Oliver Memorial Playground. I'm not dead, I said, laughing. Okay, poor word choice. The Harry Oliver Inclusive Playground. Because of everything you went through, the board committed to making this community truly accessible for everyone. The playground is the first big project. It'll have wheelchair-accessible equipment, sensory-friendly features, and adaptive swings. We want to recognize that you made that happen. I was genuinely touched. I don't know what to say. Say you'll come to the dedication ceremony in October. I'll be there. The dedication ceremony was one of the best days I'd had in years. Families with disabled kids came from all over Riverside to try out the new playground. Seeing kids in wheelchairs playing alongside able-bodied kids, everyone included and having fun, made everything I'd gone through feel worthwhile. Lawrence Martin gave a speech at the dedication. This playground represents what Riverside Meadows should always have been, a community that welcomes everyone and accommodates everyone. We fell short of that ideal, and one of our residents paid the price. Harry Oliver showed us that being inclusive isn't optional, it's essential. Thank you, Harry, for making us better. People applauded, and I felt tears in my eyes. A year and a half ago, I'd been sitting in my house feeling isolated and discriminated against. Now I was being honored for changing the community. In December, as 2026 was ending, I reflected on everything that had happened. The discrimination complaint had resolved in my favor. The settlement had covered my legal fees and then some. More importantly, it had changed policies and attitudes in my community. I'd become an advocate helping others fight similar battles. I'd made real friends and found belonging. Patricia Henderson's attempt to make me salt steps I couldn't reach had backfired spectacularly. Instead of forcing me out of the community or making me comply with impossible demands, she'd sparked a transformation that made Riverside Meadows genuinely inclusive. The last chapter came in January 2027. I received an envelope in my mailbox with no return address. Inside was a handwritten note. Mr. Oliver, I owe you an apology. I treated you terribly, and I justified it by hiding behind rules and regulations. The truth is I was wrong. I discriminated against you because I was too rigid and controlling to see you as a person rather than a problem. I've spent the last year in therapy trying to understand why I act the way I do. I've hurt a lot of people in my life by prioritizing order over compassion. You were brave enough to stand up to me, and while I hated you for it at the time, I'm grateful now. You forced me to confront who I'd become. I'm sorry for what I put you through. You deserved better. Patricia Henderson. I read the note several times. It wasn't a legal document or a forced apology. It was real, written by someone who'd done genuine self-reflection. I never responded to Patricia. I didn't need to. The apology was for her benefit as much as mine, part of her healing process. I hope she truly had changed and that she'd treat people better in the future. As for me, I'd learned something important through the whole experience. Disability rights aren't given, they're fought for. Discrimination thrives when people stay silent. But when you stand up, document everything, know your rights, and refuse to back down, change is possible. The steps that had started everything were still there, properly maintained and salted each winter. But they weren't my responsibility. They never should have been. And now, thanks to standing firm on that principle, an entire community was better off. I still lived in Riverside Meadows. I still did my IT consulting. I still played poker with Derek and the guys. I still spoke at disability rights conferences. But more than any of that, I lived without fear of my HOA targeting me again. I lived in a community that had learned, painfully, but thoroughly, that discrimination has consequences and inclusion has benefits. The irony was that Patricia Henderson probably thought she was protecting property values and community standards when she confronted me that February day. In reality, she'd started a chain of events that improved both. Property values in Riverside Meadows went up as word spread about our accessible playground and inclusive policies. Families with disabled members specifically sought out homes in our community. Community standards were higher than ever, but now they included standards of human decency and legal compliance. On February 14th, 2027, exactly 2 years after Patricia's first visit, I wheeled past those steps on my way to the park. It was cold and gray, much like that first confrontation. But this time, I was meeting friends for a walk, living fully in my community and looking forward rather than fighting battles. The steps were properly salted. The path was clear, and I was home.